Good day everyone, I'm Jelina Iduyog of BSUAD 4C, the third reporter of Group 7. So I will tackle the disciplinary process, the Article 282 termination by the employer or the dismissal, and the due process. So first, we have the disciplinary process. Disciplinary process should follow a sequence of increasingly severe penalties for wrongdoing. So the process is called progressive discipline because the disciplinary action becomes increasingly severe. So gitawag ni siya progressive tungod kay nagkadaghan na ang mga aksyon sa pagdisiplina nga nahimo ng labi na kagrabe through the employee. So the first in line of disciplinary process is the informal talk. So when we say informal talk, this may occur in a cases where the misconduct is very minor. So the next one is the verbal warning. So when we say verbal warning, it's sa mga istorya ni nga pagpasidaan. So means it is a simple comment by a supervisor to warn employees. So mga warning ni sa mga employees that a certain acts are not acceptable. So nga ilang mahang mabinuhatan is dili na maayo in the company. So the purpose is to ensure that employees know what is expected of them and that what they are doing is wrong. So this is frequently used for the minor offenses such as frequent tardiness and discourtesy. When we say tardiness and discourtesy, mga kanunay nga mga pagkulang, mga kakapoy, mga walay mga maayong batasan in the company. So the next in line is the verbal reprimand. So reprimand is mga pagbadlong, mga istorya ni nga mga pagbadlong sa mga empleyado. So verbal reprimand means that the supervisor informs the employee that the situation is not acceptable and improvement is required. So dapat jud ang supervisor jud ang mo-informs through the employee nga ilang mga binuhatan is dili na sakto and need na jud og improvement in order to have a better performance in the company. So since the purpose is to correct the problem, the employee should leave the discussion feeling encouraged and committed to improve. So need pud sa supervisor nga i-always document the discussion kung sa iyang mga warn sa mga empleyado. So the next one is the written reprimand. So naman tayo verbal na sa written. Pumagi sa pagsuwat sa pagbadlong sa mga empleyado. So a written reprimand is a written description of the problem and the disciplinary action. The supervisor prepares a written that summarizes what has been said and decided when the supervisor discusses the problem with the employee. So mag-discuss sila ang supervisor sa mga problema sa mga employee in order nga matagaan og action ang kanang problema in the company. So both the supervisor discuss the problem with the reprimand. So the employee should be warned, mga pasidan-an, about the consequences nga if he or she does not change. In her, an employee is given a written reprimand where he or she is asked to sign her name on it. So acknowledging its existence. So di man jud pwede nga magdama-damaag supervisor, dapat na jud ang employee in order pod nga ma-inform sa mga consequences. So the next in line is the suspension. So suspension is very familiar words to us, which means if an employee fails to respond to the written reprimand and persists in wrongdoing, diha na ma-apply ang suspension where an employee is not allowed to work in that certain period of time and his or her compensation is reduced accordingly. So the next is the demotion. So this step will occur when it becomes necessary to use against the employee before termination. So before siya tanggalon, nasa demotion para gamitin to use against the employee. So the last disciplinary process is the discharge or the dismissal. So which means represents the final step in the disciplinary process. If progressive discipline failed to connect the employee, the termination will result. So, ang employee gani is ma-failed na gali siya to correct his or her performance in the company. So, termination na jay. Masunod ni dya ang pagtanggal. This not be issued until all facts has been gathered and carefully considered. So, dismissal is the most drastic disciplinary step the company can take toward an employee. It should be granted a sufficient cause exists for it to be implemented. It should occur only after the reasonable steps to rehabilitate employee has failed. So, that's the disciplinary process all about. So, the next one is the Article 282, termination by the employer or the dismissal. So, there are 5 causes ni sa mga terminate. An employer may terminate an employment for any of the following just cause. So, the first is the serious misconduct. Serious misconduct or the willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work. Mani ang mga sayop nga binuhatan o mga tinuyo sa pagsupak sa empleyado in the company. So the next is the gross and the habitual neglect by the employee of his duties. So kani mga grabe na ni mga hinungdan sa pagpabaya sa mga empleyado sa ijahang pagtrabaho. So the next is the fraud or the willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. So kaning fraud is mga badlong panikas o tinuyo nga paglapas sa empleyado in that company. So the next is the commission of a crime. So, or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representatives. So, kani mga pagbuhat ni o krimen o sala in the company batok sa mga iyahang amo or bisan pagkinsang membro sa pamilya sa iyahang amo. And the last is the other causes analogous to the foregoing. So, means mga daghan pong mga mani ang mga ubang hinungdan. So, sama pa sa atong nahisgutan in the 5 termination by the employer. That's all about the article of 282, the termination by the employer. So, the last topic is the due process. So, when we say due process, it is the mechanism that ensures both rights of management to employee discipline and the prerogative to dismiss employee, and the right of the employee to a secure of a tenure is respected. So, mo ni ang mga katungod sa usa ka empleyado nga iyang i-check ang iyang seguridad sa pagpanarbaho. So, ma-respect man pud na in the company kay kitang tanan we have a rights man pusad. So, the due process has 2 elements. The first is the substantive due process, which means it provides the ground for disciplinary action, corrective, or retributive. So, it means kini naghatag ni og kanang basihan bitaw sa mga action sa pagdisiplina unsaon pag-correct through the employee in the company. So, the last is the procedural due process. Provides the procedure on how to go about hearing the side of the employee and evaluating all facts and evidences against the allegation. Means that kaning procedural due process isa sa ni siya nga way or pamaagi kung saan pagpaminaw sa side sa employee o kanang pagtimbang-timbang sa tanan niyang mga kanang facts o mga ebidensya batok sa mga allegation sa mga paratang niya in that company. So, in the company wala dyan naingon o ganun bitong night tipig-tipig kay naman dyan na rules and regulations, di ba? In order for the employee to secure the rights and also for the company. So that's end of my report. I hope that you will gain something about on my discussion, and that's it. Thank you.
Good day. I'm Mabel Alturas and I am the next reporter. Next in line is all about employee grievances. First of all, what is grievances? When you say grievances, it means a feeling of resentment over something believed to be wrong or unfair. How about employee grievances? Employee grievances is a disagreement between an employee and the employer on the terms or condition of employment. It is the complaint or dissatisfaction of an employee as regards to the place of work, scope of work, colleagues or the co-workers, the manager or the management and the policies. It is a concern of an employee in the organization as a whole. And then, when we consider the thing as a grievance, if it is minor dissatisfaction and a minor discontent is not a grievance. It is grievance if the complaint remains unattended and the employee concerned feels a sense of lack of justice and fair play. The employees may feel disturbed or dragged because of unfair treatment of the organization. Then the categories of employee grievances. First is individual or personal grievance. If one person feels he has been mistreated. Then group grievance. When several employees feel they have been mistreated in the same way. Last category is the union or policy grievance. Grievance filed by the union on behalf of a group of individuals or the whole bargaining unit or on behalf of an individuals who refuses to file it. Then, unsa may nakakos nganong naa may grievances sa usa ka organization or company? Una sa tanan is the complaints concerning wages. An employee may file a formal grievance if he receives a lower salary than a counterpart or than their colleagues who performs a same job. Next is hours of work. Employees can express frustration when they fail to get enough work hours or scheduled to work for too many hours. Then working conditions or working nature. It may be undesirable or unsatisfactory conditions of work or workplace. For example, the poor physical working conditions. Nan banha kaayo, hugaw kaayo ang mga kagamitan or ang palibot, then the faulty machines and equipments. The strained relations or maybe their workplace is noisy and employee can focus to their work. Next in line is the performance evaluations. It may be grave on the grounds that it is allegedly inaccurate. An employee may feel that it is unfair of judgment about their performance. Then, workloads or job assignments. If you work for a company that is going through lean times, you may have been asked to take on more work without a pay increase. Then, or another is the interpretation or application of a rule, regulation, and the policy. In order for a grievance to be processed, the employee must follow proper procedures and file in a timely manner. Grievances procedures in unionized firms as provided in their CBA. First is Submitting the grievance to the immediate supervisor. In a union environment, a typical grievance procedure begins with an employee presenting a problem to his or her immediate supervisor within a certain time period after the offending event has occurred. Second is submitting the grievance to the employee's union's representative. At this point, a union representative enters the negotiations on behalf of the employee. Third is submitting the grievance to the top management representative. If the situation is still resolved, the grievance continues up the chain of command to the plant manager and the president of the local union. If the labor union fails to follow the procedures at any point, the contract usually specifies that it must drop the grievance. And the last procedure is submitting the grievance to arbitration. This is done if a satisfactory solution to both parties is not reached by the above procedure. This is the final step in the grievance process, and both parties agree beforehand to abide by the arbitrator's decision. As provided in the Labor Code, all grievances that remain unresolved after exhausting all the internal procedures shall automatically be referred to arbitration. And that's all for my report. And the next reporter will be Rosemary Dayua. And that's all. Thank you.
Good day, everyone. I am Rosemary C. Dayuha, the fifth reporter of Group 7. So I will be tackle the continuation of employee grievances. So there are two periods in the grievances procedure. So the first is the period of persuasion and the second is the period of arbitration. So period of persuasion. From the word persuasion, it has the act to do something in order to attract or to believe one's position through the reasoning or arguments. So this period of persuasion takes place from the first step to the last step immediately prior to arbitration. So this is the first thing to do before moving on arbitration. And this arbitration is a method of resolving a conflict or to settle a dispute between an employee and their employer. And with the use of arguments and evidences, each parties persuade one another to give into one's position or they agree to a compromise. So the second is the period of arbitration. So it begins when the act of persuasion has been exhaustively used and no settlement has been reached. So this period of arbitration is the next thing to do if there is no settlement happened and that has been reached between the two parties. And as I've said earlier, the arbitration is a method of resolving a conflict. The employer and the employee will select an arbitrator who will listen to each side and make a decision about the case. So the next is the processing of grievances. And according to Perfecto Fernandez, processing of grievances involves a joint effort on first is the identification of the issue or issues involved. So the main issue involved in the conflicts really needs to be identified, and with that, it can be clearly identified why it has come to the point that there are grievances happen between the employee and to its management. So the second is the developing the factual basis or background. So it is important to present the factual evidences or any arguments so that the quarrel of both sides can be easily settled. And the third is determining the contract provisions involved. So you will find out those application or agreement contract that are involved by themselves which needs to be settled. So the fourth is evaluating the merits of the grievances. So after that, all of the qualities of the grievances must be examined or need to assess. And the last is working out a fair and just settlement. So everyone should be fair and balanced in working in an organization. So there is no bias and complaint between employee and employer, and for everyone to get along. And with that, there will be settlement for both parties. So the next is the grievances procedures in non-unionized firms. So when we say non-unionized firms, it is a company or an organization does not employ workers who belong to a labor union, and in non-unionized workplace, an employer can pay employees who do the same job with different amounts. So there are different steps in the grievance procedures usually involve the following. So first is the presentation of employee problems to the supervisor. So the first thing to do is that the employee will present his or her evidences or arguments to the supervisor so that the problem will be settled within the specified period. So second, if not satisfied, the employee can elevate the complaint to the next higher level to resolve the grievance. So, if the employee is not satisfied to the supervisor, then he or she can raise up regarding to with his or her complaint to the HR manager or the CEO of the company. So, the third is that the problem may taken to arbitration for final decision if no satisfactory solution has been reached by the above procedures. So, if the problem will not resolve, then it will immediately prior to arbitration in order to resolve the conflict or to settle the dispute. So, that's all for my report. Thank you and have a nice day.